Hello and welcome again to Immigration News and Views. My name is David Nachman. I'm one of the managing attorneys of the NPZ Law Group, Nachman Fulwani Zimochek. And we have offices located in Ridgewood, New Jersey. We also have an office located in Midtown Manhattan. We also have an office located in Indianapolis, Indiana. And we have a presence in Boston and Chicago for the convenience of our clients. And so today I wanted to quickly discuss with you a new precedent decision that came out from the USCIS, which deals with an area that we handle very frequently. It's the intra-company transfer visa L1A. And as I've described in several of our videos in the past, I think maybe before we get to the precedent decision, I'll tell you a little bit about the history. And that is that for L1As, there are two ways that an argument can be made that an individual is a manager in an organization. There are two ways, of course, to argue that an individual is an L1A. One is to say that they're a manager, or two is to say that they are an executive. So here, if a person is designated as a manager, there are two ways to argue that an individual is a manager. The first way is to say that an individual is what we call a traditional manager. A traditional manager is usually an individual who is has a hierarchy under them where they are managed by an individual above them, and then they manage individuals below them. And usually those individuals who are managed below them are of a professional nature, and oftentimes on a request for evidence from the USCIS, there's a question about the academic skill sets and also the experiential skill sets of the individuals who are being managed. There also are questions about the individual's salary and often questions about what the day-to-day functions, responsibilities are, and what time is allocated in the day to those responsibilities. So those go to the issue of what we call a traditional manager. And in the day when we were arguing traditional manager, we still argue traditional manager as to why an individual is a manager. We also focus on issues of like ability to hire and fire. We also talk about the value of the responsibilities that the individual is undertaking. For example, if you have an individual who's making multi-million-dollar decisions on a day-to-day basis, of course, that goes to the heart of whether or not they're considered to be managers. Now, what happened then in the early 90s was this new concept, and again, the traditional manager is where you have a corporate chart that is listed out, boxes upon boxes, and it's very vertical in structure, and a little bit horizontal, but generally vertically. And so then what happened was in the early 90s, of course, new ways of doing business took shape. For example, IT companies started to deal with people all over the world, and communications were very different. So what happened was the traditional management function flattened out. And so rather than having a traditional hierarchy with the boxes one above the other, rather we saw more of a nodal, where it was like a circle with little boxes that were attached to each other, and that was what we called functional management. So the precedent case that came out recently deals with functional management, and it was really a very nice and interesting case because what the case did, it dealt with a Japanese company, and what they did was they said that even though the individual was with a small Japanese company in the United States, which was a subsidiary of the foreign organization, the foreign organization was a huge Japanese corporation, and the individual who was in the United States, although it was a very small company in the United States, was managing the functions of the individuals who were in the Japanese company abroad. So this was the first time where we had seen that the USCIS gave credence to the fact that it was okay for an individual in the United States to manage the staff abroad. And so many of the cases that we have in our office, and many of the cases that when we're approached by new and potential clients, have to do with situations where they're getting their foundation or their footing in the United States, and oftentimes that requires them to be directly managing individuals who are in various professional level functions abroad. So what we're tending to find is that this type of an argument now for functional management, of course, can be enhanced, and it can be used both for the traditional management argument and also for the functional management argument. So hopefully this opens doors to new ways in which the U.S. immigration, USCIS, U.S. Customs and Immigration Service, can look at the way in which management is taking place in new startup organizations or smaller organizations in the United States. So it's our hope that obviously more liberal interpretations will be given to these types of cases in the future. So as these precedent decisions come out, and obviously as the interpretations of these decisions are promulgated, we'll try to bring that to you as best we can. So thanks very much for tuning in, and we look forward to seeing you soon. Bye for now.